Assalamualaikum and selamat sejahtera to everyone. My name is Denisha Kabirizwan and I'll be presenting about the introduction of winding up. Okay, so before we go through winding up in detail, let's go through a simple and brief introduction of what is winding up in the companies. Winding up is a formal legal process under the Companies Act 2016 that brings a company existence to an end. It marks the final stage in the life of a company. During this process, the company's assets are collected, valued, and sold. The money received is then to settle the company's debt and liabilities. If there is any remaining balance, it is distributed to the contributors, which are shareholders who are liable to contribute to the company's asset. Winding up can be done by two methods, which consist of voluntary winding up, which was winding up that initiated by the company itself, or winding up by court, which was initiated through a petition and ordered by the higher court. Therefore, winding up is an essential concept in corporate law because it ensures accountability, fairness, and compliance when a company comes to an end. Winding up ensures that the company is closed in an orderly, transparent, and lawful manners. So that's it from me. I'll be passing to the next presenter. Thank you.
Good morning, madam. My name is Sani Hajika, and I will be presenting about the process of winding up. I will start with the process of winding up for voluntary winding up. And we got in total of 6 steps. The first one is winding up. What is winding up? Winding up is a process that started by voluntary by the company's members, only allowed when the company is solvent. The purpose is to close the operation in orderly way to pay all the debts of the company, and it doesn't need any involvement of the court unless it is issue arises. First, what is the first step? The first step is declaration of solvency falls under section 443. The directors must make a formal written declaration, and they must state that the company can pay all the debts within 12 months. And it must include with the statement of assets and liability, which ensures that the company is financially stable enough for the members voluntary winding up. Following up with the second steps, which is special resolution, falls under section 439. The members must pass a special resolution with the approval of 75% of shareholders of the company. And this resolution officially starts at the voluntary winding up, and it must be filled with the SSM, and the notice of winding up must be published. And for the third step, which is appointment of liquidator, falls under section 444. The members must appoint a licensed liquidator to take over the process, and the liquidator replaces the board of directors, which means the power of the director are no longer existed. This falls under a different section, which is section 477, and liquidator becomes responsible for handling the company's affairs. For the fourth step, the liquidator's duties, which is from under section 486 until 493. The liquidator must take a position of all the company property and also records. And then it has a release asset. It must release asset like need to sell the property and collect all the receivables and pay the creditors in full since the company is solvent, and continue legal action on behalf of the company if indeed. And it also must prepare the accounts of receipts and payments during the winding up process. And go for the last step, which is final meeting of members, falls under section 459. Held after These steps only held after all the assets are sold and debts are paid. The liquidator prepares a final report and statement of account, which is for the members to meet the view and approve the final accounts. And after this, it just marks at the end of the liquidator's active duties. The last step, which is the sixth step, will be dissolution, which falls under section 459, bracket 5. The liquidator files documents with the SSM after the final meeting, and after 3 months, the company is finally dissolved. And the company's name is removed from SSM and the company no longer exists in a legal entity. So that's all for the voluntary winding up process. I will continue with the by court winding up. So let's continue winding up by court. By court winding up means that a winding up carried out through a court order, which usually happens when company is insolvent, and the High Court supervises the entire process. It is more formal and stricter than voluntary winding up because it involves big court. And the first step, in total, we got 8 steps for this. And the first one is filling of a petition under section 464. A petition may be filled by a creditor, most common. It is used, and the company itself, or maybe a member, maybe the registrar, and the petition sets out reasons why the company should be wound up. For the second step, which is grounds for winding up, falls under section 465. The court may wind up a company for reasons such as unable to pay the debts, it is just an equitable, maybe the company has no members or the company acted against public interest, and lastly, it could be because of the director engaged in fraud or misconduct. But most commonly, it will be unable to pay the debts. The third step will be the insolvency test under the section 466. Since a company is deemed unable to pay the debts, it needs to conduct some tests, and it is only applicable if it falls under it owns more than 10,000 of debts, and a creditor issues 21 day of notice of demand, the company fails to pay within 21 days, and discard of legal grounds to order winding up. For the fourth step, it is court hearing and winding up order falls under the section 467. The court examines evidence and hears argument. If it's satisfied, the court issues a winding up order. And if the winding up is deemed to commerce from the process of the order, the court may also give directives on managing the company. For the fifth step, which is appointment of liquidator, falls under section 479. The court appoints either the Director General of Insolvency, DGI, or a licensed liquidator. A licensed liquidator replaces all the directors and controls of the affairs of the company, same as voluntary winding up. And the last step for these slides is liquidator tax control. This is under the section 477 until the section 478, and the liquidator must take possessions of all the assets and record, investigate company dealings and directors' conduct, sell the asset to raise more funds, and defend or initiate legal actions for the company. And other than that, it also prepares and record a proper financial accounts and report misconduct if discovered by him. So I will continue my step 7 and 8 with the next slide. Let's continue with the step 7 and also step 8. The step 7 will be the priority of payment, which falls under the section 527 and also the section 528. The liquidator must distribute the money in strict order, which it has the priority on top. The first one will be the cost of winding up, which is like court or liquidator's fee. The second one will be secure creditors, which is the company debt, and preferential creditor, which is like employees' wages, taxes, or maybe EPF. And the fourth one will be unsecured creditors, and the lastly will be shareholders, and if it is only if there is any any money left in the company. And the last step will be dissolution, which falls under section 481. The liquidators must prepare a final account for the court, and the court must review and issues an order for the dissolutions. The company is dissolved if dissolved and it's no longer exist, and that's all. That's the end of the winding up by court, and that's all from me. Thank you.
Okay, so thank you to Aneha. Now I will be presenting about the types of winding up. Before that, let me introduce myself first. My name is Nurul Afifah binti Sabir. There are two main types of winding up. The first is voluntary winding up, which is started by the company itself, just like Danish said. And this can happen when the company is still financially healthy and the members has decided they no longer want to continue the business, or when the company cannot pay its debt and choose to close in an orderly way. In this type, the company has more control over the decision and the overall process. Next is winding up by the court, which happen when the court steps in and order the company to be closed. This usually occurs because the company fails to pay its debt, faces serious dispute among the owners, or is being mismanaged. In this case, the court takes over the process and appoints a liquidator to handle everything. So now let's look at the key differences between voluntary winding up and winding up by court. The first difference is who initiates the process. So voluntary winding up is started by the company itself, usually through the members or creditors who agree to close the business. On the other hand, winding up by court is initiated through a court order, often after someone files a petition, like creditor or shareholder, even the company itself. The second difference is the reason for winding up. Voluntary winding up usually happen when the company plans to close because the member decided it is no longer necessary to operate, or the company become insolvent and wants to settle everything properly. Court winding up, however, happens mostly because of more serious issues such as inability to pay debt, internal dispute, or misconduct, or other situations where the court believes the company cannot continue operating. Next is the control of the process. In voluntary winding up, the company has more control over decision making because the members or creditors choose the liquidator and manage the overall timeline. But in court winding up, the entire process is controlled by the court-appointed liquidator, and the court supervises every major step. Another differences is the cost and the speed. Voluntary winding up is usually faster and cheaper because it avoids long court procedures. The company simply passes a resolution and appoints a liquidator, while court winding up, on the other hand, tends to be slower and more expensive because the process involves legal hearing, investigation, and formal court oversight. So overall, the main difference focuses on who started it, why the company is closing, who controls the process, and how much time and money the company will spend. Voluntary winding up is generally smoother and more flexible, while winding up by court is more formal and usually used when there are serious financial or management problems. And that's it from my part. Now I'll be passing to the next presenter, and thank you.
Assalamualaikum and hi, my name is Ainadira Ahinra. I will continue presenting the slide with the subtopic grounds for winding up. Now, I will explain the grounds for winding up a company under Section 465 of the Companies Act 2016. First, under Section 465(1)(a), the company may be wound up if it has passed a special resolution agreeing to be wound up by the court. Second, under Section 465(1)(b), winding up can occur if the company fails to lodge the statutory declaration required under subsection 193. Third, under Section 465(1)(c), the company may be wound up if it does not commence business within 1 year of incorporation, or if it suspends its business for a whole year. Fourth, under Section 465(1)(d), winding up is possible if the company has no members. Lastly, the section for the slide under Section 465(1)(e), the company can be wound up if it is unable to pay its debts. Next, I will continue with the remaining grounds for winding up a company under Section 465. So, under Section 465(1)(f), a company may be wound up if the directors have acted in their own interest rather than in the interest of the members as a whole, or if their action appear to be unfair or unjust to the members. Next, under Section 465(1)(g), winding up may occur when the period stated in the company's constitution has expired, or when an event specified in the constitution requiring the company to be dissolved has taken place. Also, under Section 465(1)(h), the court may order the company to be wound up if it is of the opinion that it is just and equitable to do so. The second last one is Section 465(1)(i). A company may be wound up if it has held a license under Financial Services Act 2013 or the Islamic Financial Services Act 2013 and that license has been revoked or surrendered. Lastly, last but not least, under Section 465(1)(j), the court again has the power to wind up the company if it is of the opinion that doing so is just and equitable. These are the additional grounds for winding up provided under Section 465, Companies Act 2016. Thank you, that's all from me. I will pass the next present to the presenter.
Hi, I'm Ashira here. To conclude my presentation on winding up, I would like to summarize the key points that we have discussed. Winding up is essentially the process of bringing a company's existence to an end. During this process, the company assets are collected, realized, and used to settle its debts and liabilities. If there is any remaining balance, after all creditors have been paid, it is then distributed to the contributories. This marks the final step before the company is dissolved. There are two main methods of winding up, which is voluntary winding up and also winding up by the court. For court order winding up, several parties have the right to file a petition. This includes the company itself, creditors, contributories, a liquidator from a voluntary winding up, the minister, Bank Negara Malaysia, or even the registrar. Each of these parties may petition based on their legal interest in ensuring the company is properly dealt with. The Companies Act outlines several statutory grounds under which the court may order a company to be wound up. These include situations such as failure to file statutory reports, failure to commence business, having the members, and the company's inability to pay its debt. The court may also act where directors have act in their own interests rather than the company's, where the company has exceeded the duration stated in its constitution, or where its license has been revoked. Another ground is when the company is being used for unlawful or fraudulent purposes. One of the most important and flexible ground is the just and equitable ground. This allows the court to step in when fairness demands that the company be wound up. Examples include failure of the corporate substrator, fraudulent business conduct, deadlock among members, and also loss of confidence in management. These grounds are important because they ensure that a company is not allowed to continue operating when it is no longer able to fulfill its purpose or when its operations threaten stakeholders. In summary, winding up provides a structured and legally supervised way to close a company, protect creditors, and ensure fairness to all parties involved. It ensures that the company's affairs are settled responsibly before it is finally dissolved. And that's all from me. Thank you.